Okay, let's get started. Just first of all, I'm Hiroshi Motomura, faculty co-director of the Center for Immigration Law and Policy. And again, thanks for all of the engagement and questions you've had during the day. It's been a really rich discussion. And it's my privilege to introduce our third panel. And I think it fits very nicely into an arc that, just to name it, I mean, we started with infiltrators and focusing on detention from the perspective of activism and thinking about detention really from how it affects the people in detention and how it relates to broader political movements. And then we took a step back for more of a 30,000, 50,000 foot view of change and the movement in Ingrid Egley's conversation with Cecilia Wong from the ACLU. So now I'd like to introduce this panel, which really addresses the question, should immigration detention be abolished? So I'm going to limit myself to introducing my friend and colleague, Nina Rabin, who will introduce the panelists. And I'll let Nina take over and run this to about 3:30 in a minute. But I do want to take the opportunity to say a few words about Nina. This is partly institutional, but also personal reflection. I think here at UCLA Law, one of the best things that's happened to the law school over the past several years has been that Nina joined us from University of Arizona to become the founding director of the Immigrant Family Legal Clinic. So this so-called IMFAM clinic, that's what we call it here, is really a true centerpiece of student training in immigration law and immigrants' rights here at UCLA. It's a clinic that runs on the Robert F. Kennedy campus of the Los Angeles Unified School District. And so Nina's been a leader in that, founding the clinic and shaping it and being a big influence on the shape of legal education in the immigration space here at UCLA. But I also want to say that Nina's done path-breaking scholarship on a variety of issues on immigration law with a particular emphasis, just to name a few. This is just examples, immigration enforcement and detention, how things are on the border and in border communities for children in schools. So Nina's a model of an academic who engages in immigration law, both as a scholar and as a teacher. And I'm really eager to hear, Nina, how you lead this panel to deal with the tough issues regarding immigration detention. So Nina, the floor is yours.
Well, thank you so much. I was not expecting that at all. I thought it was my job to do the introduction. So thank you. That's so kind and means a lot. And really, it is just an incredible honor to be a part of this whole conference and this particular panel. And I think that the panelists that we have just are ideally situated to bring such rich perspectives to the questions about detention at such a key moment in detention advocacy. So I'm eager to maximize our time to hear from all of them, but I do want to, my introductions will not do them justice, but give some brief introductions for each of the panelists before we get into it. And then what I'll do is, we wanted to, rather than have any kind of formal presentations, we thought we would mostly have this run as a conversation. So I'm going to be posing questions to them and plan to do that for about the first hour, but please do put questions in the Q&A box, and I might not turn to it until 3, but definitely with 30 minutes left, I'll turn to questions from the audience and do my best to, there's a lot of people, but we'll try to cover questions from you all as well. So as I said, we have a fantastic panel. First, we have Munmeeth Soni. She is the Director of Litigation and Advocacy at Immigrant Defenders Law Center, or IMDEF. And she's represented numerous detained immigrants against deportation and also participated in systemic litigation on a variety of detention issues. She has a distinctive expertise at the intersection of immigration law, criminal law, disability law, and constitutional law, particularly how all of these intertwine in the context of immigration detention. And before her work at IMDEF, she worked on asylum and deportation defense in the immigration unit at the Public Law Center. She serves as an adjunct professor at both UC Irvine School of Law and the Western State College of Law. She's the recipient of numerous awards for her outstanding advocacy. And through her litigation, she's resulted in important published decisions in the Ninth Circuit, including ones that I have relied on very often. I was excited to see that that was due to her tireless advocacy. So really happy to have her join us. Next, we have Margot Schlanger, who is the Wade H. and Doris M. McCree Collegiate Professor of Law at the University of Michigan, where she teaches con law, torts, and classes on civil rights and law enforcement and immigration. In the Obama administration, she was the presidentially appointed officer for civil rights and civil liberties at DHS. And she's also served on DHS's advisory committee on family residential centers, where that committee recommended abolishing family detention. And perhaps most striking to me, in addition to all this work as a scholar and a public servant, she's also gotten directly involved in litigation as an expert and monitor in prison and detention cases, and by serving as class counsel in Hamama via Ducci, a national lawsuit that successfully opposed deportation and detention for hundreds of Iraqis that the Trump administration sought to deport. I had the opportunity to work a little bit with Professor Schlanger when I represented one of the class members' cases, and her leadership and coordination of this incredibly complex class action was really a thing to behold. So, so happy to have her on the panel. And then third, we have Nia Nourn, is the community advocate for the Immigrants' Rights Program at Asian Americans Advancing Justice Asian Law Caucus. She's also a directly impacted, formerly incarcerated domestic violence survivor who, after serving over 15 years in prison, was immediately picked up and put in detention by ICE. There was an outpouring of advocacy from community groups around California, and she was released from detention. And ever since, she has worked tirelessly on behalf of others, working on coalition building and policy advocacy at both the local and national level. She's testified before the California State Assembly and US Congress on conditions faced by incarcerated people in prison and in ICE detention. She volunteers and serves on the board of several organizations working directly with incarcerated people. And in June 2020, Governor Newsom granted Nia a full unconditional pardon, preventing her deportation to Cambodia, the country that she fled as a child refugee. So we're really lucky, and really it's humbling to have her perspective on this panel as somebody who has experienced immigration detention firsthand and now brings that knowledge to bear on the greater movement. So we're so glad that all of you could join us. And I wanted to start us off by just reflecting on the moment that we're at in the movement, because I think it's a pretty amazing and feels like kind of a crucial, critical moment. We've gone from, this breathtaking number of people detained on any given day. It just kept climbing and climbing to reach over 55,000 in August of 2019. And now suddenly we find ourselves with around 13,000. That's still plenty of people in detention, but a really dramatic decline. And I just would like to hear the panelists' perspectives on what they think. Are there indications? Obviously, some of this decline was because of the pandemic. Are there indications this number is going to stay low or even continue to decline? Do you think, to tie this into the topic of the panel, is total abolition a realistic goal? And is there ever any kind of detention that's appropriate, or is that the goal we want is total abolition? So I don't know if any of the three of you want to start, and would love to hear from all of you.
I think Meet should start.
Perfect.
Yeah, I'm excited to take that question, in part because it really, I don't think that we could have ever imagined that it would actually be this sort of, I mean, it's a confluence of many factors, but for sure what happened under the pandemic and the fact that because of really IHLON and ACLU's litigation, at least I could speak to it in California and in elsewhere, the fact that advocates kind of took this moment to really sort of use this opportunity to, I think, bring a lot of awareness about the conditions taking place inside detention facilities and how unsafe they were. And the fact that in this moment during a pandemic, they were just, I mean, all over, they were just kind of like these hot houses, hot spots, right, if you will, for where the virus was going to explode and spread like wildfire. And sure enough, it did in Otay Mesa and Adelanto and facilities across the country. And I think that when the public started really realizing that and understanding, of course, that COVID is what a threat to them, I think all these sorts of points that we had been advocating for over the last few years in terms of horrific conditions of confinement, the private prison complex, the private immigration detention complex, the fact that immigration detention is civil, it should never be punitive, I think has now brought us to this moment where we're seeing these record low numbers. And I have full confidence that we're not going to see going back to the 55,000. I don't think that that's what this administration is going to do. I don't think that we as advocates through all the litigation that's gotten going is going to allow that. I think the judiciary too have become much more aware of what takes place inside these facilities, that they never had an opportunity to really look with that type of scrutiny before. So I'm very positive. I'm very hopeful about this moment, and think that it really has like ushered in a new chapter for us. Where I think this is going to go and whether it should, I think that to the point of abolition, I absolutely sort of support abolition, the abolition movement, especially when it comes to immigration detention, because there is no, I mean, as we say, it's civil. There's nothing punitive. It should not be punitive, and that in and of itself, sort of, I think for me, answers this question of whether we should ever have, whether we should even be detaining anyone. So that's kind of where I see things, and I think that we've picked up a lot of momentum. There seems to be a lot of great sort of awareness within the administration that we can push them on, and so yeah, that's where I think things are going to go. I hope that answered the questions.
I'm happy to go second. Thank you so much for having me. It's really an honor to be at this amazing gathering. I think the Trump administration increased detention well past what it had been in the Obama administration, but it was very high under President Obama. Let's just be clear, 35,000, and it was always set by Congress what they thought detention should be. It was always available to the administration to push back harder than it did, but the kind of prod to increase the numbers came from Congress. I think having seen that it is possible to lower the numbers, I feel pretty good about the prospects of the Biden administration keeping them low. I think the prospects of abolition are, less sure by a lot. I think that it's one thing to get rid of immigration detention as the system that it has been recently, which is a kind of purportedly public safety preventive detention measure, which takes people with records from the criminal justice system, waits till they've served their full sentences, and then says, oh, but you're too dangerous to let out into the community, which I just think is, I think it's against all the principles that we have under the due process clause to not do preventive detention, to say people serve their time and then they're out in the community. And there's nothing to say that immigrants are more dangerous than anybody else. In fact, there's quite a lot of evidence to the contrary. So I think that hopefully that will go away. That said, another purpose of detention under the current system is to facilitate removals. And I think the idea of abolition, if there is still an active deportation system, I think those prospects are pretty dim. And I think that people who want immigration detention to go all the way to zero are essentially saying that they want not maybe removals, that's really part and parcel of a system that says not one more about involuntary repatriations of immigrants. And so I think that that's a piece of what's going on. That said, we could have very, very, very low numbers without hitting that last chunk. And I think we should. 13,000 would have seemed unimaginably low a few years ago, although honestly, it's also the same number from the 90s. I mean, it's not, and from the early 2000s. It's not like we've not been there before. But so I guess what I'm trying to say is that I feel like the numbers are likely to stay low, but unless there's a pretty drastic change in deportation policy altogether, we're unlikely to get to zero. And that's really what abolition amounts to, is a request for a drastic change in the removal system, all told. I guess one last thing to say is this. We talk about civil detention, but let's be clear that nobody has a vision for what detention could look like that doesn't essentially have it looking like jail or prison. There is, and that's why the abolitionists, I think, are, I think that lends a lot of power to abolitionism, that there isn't such a thing as mass detention that is really civil. The conditions of confinement, the physical layout, the supervision, the training that's given to the people who run detention, the rules that govern detention, every one of those things takes its full flavor and its ancestry is all in jails. And I don't see a way, I don't see a system that loses that basic feel and substitutes a kind of detention that doesn't feel like jail. I think it's much more plausible to just amp down detention rather than trying to run a different kind of detention.
Yeah.
Hi, everyone. Thank you so much for having me. It's an honor to be here. So this three-part question. So the second one, truly, I believe abolition is necessary. It's really crucial, and it is something that is realistic. Before I get to that, just to answer the first question, do I see any promising indications that the number will stay low or decline? I think for myself, because with the Trump administration and with the pandemic, I only will see it only going up when the pandemic's over, when things are back to normalcy. And I say that because you know, the Biden administration's is like Obama to continue adopting the same rhetoric around deporting people that are in prisons, formerly incarcerated, like immigrants, right? That will definitely point to the enforcement priorities with felony convictions. And also the fact that the California prisons are opening up detention centers as well. So I think really that in order to see what criminal justice is to also work on the abolition front, where that it's necessary, especially in the local and state level, that California as we see, has proven that it's really possible, right, with these sanctuary policies that we have. Then in terms of the framework for it, for advocacy, while the local and the level is working on that and in ending ICE transfers and ICE detentions, that I think also on the federal level that that we have to look to the organizers, the locals, and the statewide that are protecting, immigrants and refugees, and the work that they're doing, right? I think that's really essential. And I think that, especially with the bill that we're working on in California right now, the Running the Vision Act, is AB 937, it would strengthen, it would stop all ICE transfers from jails and prisons. And that's building from the Trust, the Truth, and the Values Act. And as we see, the reason why it's building is gaining ground momentum because local and state lawmakers are realizing that immigrants and refugees that have served their time in prison, why are they being doubly punished, right? If you want to say they're rehabilitated, we believe in, that why should they be continued to be criminalized further because of where they're born, as immigrant status, especially with convictions that are decades old. I think speaking for myself, right, even before my incarceration, I didn't realize that even despite being as a permanent resident, that I would be facing deportation, that you're excluded because of your conviction. And I think that's just very wrong and inhumane. That if the Biden administration wants to continue on pushing on reform, on immigration policies, that they must realize that we have to lift from the bottom up to recognize everyone's humanity and not just see it for their conviction alone, to continue to punish them. And yeah, I'm really looking forward to, working, continue to pushing, the narratives that abolition is necessary in order to see a world where we imagine without policing, without borders, without detentions, because my vision is that detention period, jails, it's not, there's no way of reconciling or saying that, what are the alternatives? And for me, the only alternatives, again, from my experiences, from the work that I do, from team members and from families and loved ones, from hearing them and knowing their stories, that abolition of all detentions is necessary, is crucial.
So there's so many things I want to follow up on, but I think maybe just this, it's really interesting that I think both Margot and Nia are saying that abolition as the goal is in some ways requires these fundamental rethinking of the way the system operates, but that I think what Margot was suggesting was that maybe that makes it not the best goal because we're dealing with a system that does deport, and if there's going to be deportations, then there is a limited use of detention that might continue to be necessary. So I just want to push on that a little bit more and hear about, like, operating in the system, are there some uses of detention that you all as advocates can live with, or is really abolition, is it important to have abolition be the bottom line? And I think I'd like to weave into that also thoughts about alternatives to detention, like how much should the advocacy strategy be to replace some of the structural role that the detention serves with alternatives to detention, or are those also problematic in their own way? And I'm thinking here particularly of, electronic monitoring devices, the kind of surveillance that goes along with that. Is that sort of the direction that this leads to if you are talking about when you're still operating with a system with deportation needing some means of ensuring that the system is working. So I'd love to hear people's reactions.
Maybe I'll start on that one. Or Meet, did you want to?
Well, I did insofar.
Go ahead.
Just actually because some of the points that Margot you had raised with respect to like the certain needs of detention for purposes of facilitating removal, right? For instance. And to that, I'm curious to hear what you have to say, because I want to push back a little on that. You know, within, I'm not sure how much, I mean, the system, you know, to the extent that majority of the people who are in removal proceedings are actually non-detained. And in that context, when someone does have a removal order issued against them, they're, you know, ICE does not need to detain them. And oftentimes, if they just go ahead and make sure that they are, that they leave the country by a certain date and then check in with the consulate, that's sufficient. So the system, there is a whole system that is working where people, you know, follow those orders. And I do think that to some degree, we just kind of have to unpack this idea of like, well, why, you know, I think that this notion that we need to facilitate removal is in large part predicated on this belief that most people, if they know that they have to turn up for removal, are actually going to run away. That more people would sort of try to abscond than they would actually try to comport. And I don't necessarily think that, I'm not sure I've ever seen numbers to support that, but I could tell you in my experience of working, you know, that more often than not, so many of the reasons why people fail to appear at their immigration hearings, fail to maybe not even knowing that they have a removal order against them, has a lot to do with the fact that the system itself is designed to trap people in that way, right? So hearings will not go out properly. People don't realize that there's like an automated phone system. We have no access to counsel, right? There's not like this mandatory right or, you know, government given right to be able to have counsel. And when you don't have counsel, I mean, everyone, I'm sure my panel can attest to this, is that those who are pro se, the system is stacked so much against them, and it doesn't actually properly inform them. I mean, and it really can't give them, I think, a meaningful sort of sense of what they need to do, what their rights are, how to protect themselves, what their defenses are, because it's so complicated. So I just, you know, kind of want to put that there, because I think that we do have this sort of bias that I don't think that sometimes we ourselves question, like, where does this notion of flight risk come to? You know, I get that it's part of the statute, but I think that, you know, that kind of like, there's like this sort of, there's historical underpinnings there, right? In terms of always with how we view immigrants and people who want to be able to immigrate to this country. And that there's always this sort of sense that they're not law abiding, that they're going to do whatever they can take to remain here. And I don't think that that's just not true. So sorry, that didn't, but.
I don't really want to, let me say this. I am absolutely committed to the idea that our immigration detention system is massively too large, that it has been for quite some time, been massively too large, and that decreasing it by, from that height down by, you know, many percentage points, not just by a majority, but by a huge amount, is absolutely the right thing to do. And that any rational system that doesn't do what Neo was talking about, that doesn't say, well, you know, people who have served time, we're going to just assume that if they're immigrants, that they need to be locked up more after they've served time. And I just think that's wrong, that preventive detention like that is A, unnecessary, and B, you know, inappropriate. But so I don't necessarily, I mean, I was sort of, I think, invited to this panel as you know, the rightmost person on it, but I'm not very far right on this stuff. I just, you know, that said, I think it's a lot to expect recent entrants who are being removed to make their own way back to their home country. I think that's a lot to expect. The people who you're talking about where they go back to their home country after deportation and then they report to a consulate are not people who just made their way here a few weeks ago. And yet there's a fairly big proportion of the deportation docket that is such people. So I guess I think that I'm also, I should just say, I think that what we do with people when we deport them is where we take them and we drop them off in the middle, often, not always, but often in the middle of nowhere with inappropriate clothing and no ID and no money. And like I think our sort of just very nitty gritty repatriation practices are terrible. So I guess what I think is that if there's going to be a deportation system that deals with recent entrants, we're going to have some, buses and planes that do that stuff, and that it's not crazy to think that people who got here fairly recently, who don't have functional American lives because they don't have American lives because they're being deported too quickly, that it's not crazy to think that that's a piece of the system. That said, like I really like I know that puts me that puts me on, like on the right wing of this conference, and I don't necessarily want to live there. I'm very happy for people to A, prove me wrong, and B, advocate for abolition, because honestly, if we're going to get detention down to a few thousand, the way that's going to happen is by abolitionist advocacy. So I'm not against those arguments. I just, I'm more committed to the get detention down to a few thousand than I am committed to the get rid of those last few thousand. That's kind of where I come. But I want to turn to Nina's point about alternatives to detention, and in particular to what people call tethers or ankle monitors or whatever, which let's just be clear, are both theoretically somewhat problematic because surveillance, but are also just practically very difficult devices to cope with, because they tie the people who have them to having to be by they're uncomfortable, often painful. They tie the people who have them to have to be by internet access and to have to be by a recharging outlet. They are difficult devices, but they're one heck of a lot better than detention. And so I think, as with all kind of ameliorative measures, this puts us as advocates, and it puts the communities affected in a very difficult position that bears really talking about, which is, I don't think there's much question that people who are in detention are better off if they could have ankle monitors instead, but they'd be still better off if they could just have call-ins. And if we have a system of ankle monitors, maybe instead of it being X thousand, it's X thousand times 10. And so my own view is that systems like this need to come with policies that keep them from being very net widening, that keep them being substitutes for what would have been a more restrictive infringement on liberty, and that it is really important for the government to do as many things as possible to make them as unonerous as possible, to have longer batteries and to have them be less uncomfortable and to not make people pay for them. And I mean, there's a whole host of policies, but that we should not, that if we give our clients the choice, and I have had conversations with my clients about this, if they have the choice between detention and ankle monitors, it's a pretty rare client who wouldn't pick an ankle monitor. And it's not right for advocates who just say the word surveillance to say, well, no, I don't want that because surveillance, that's not doing our clients any favors. And that if communities get to choose, and I think they should, that a reasonable, unnet widening, carefully structured, as unabusive as possible ankle monitoring system is preferable to detention.
Nia, I don't know if you have thoughts about that or the previous exchange.
Yeah, I think, sorry, my internet went a little bit wonky, but I'm back on. Margot, I think I missed the first minute of your talk. But I think to Meeth's point, in terms of ankle monitors, I think for me, it's really unnecessary. But I understand Margot's point that if it's an alternative, right, whether it's detention to be released, then of course they're gonna pick, ankle monitor, because who wants to spend another one day in a detention that doesn't provide any safeguard for the health, for the mental well-being. I think for my own personal experience, like the 6 months that I was there, it felt like 2 years. It really took a physical and mental toll on me. Yeah, I think also people that are on ankle monitor, even today, they really, I think ICE wants to push this narratives that we want to detain folks or we want to put them on ankle monitors to make sure that they're not a risk, right, to the community as safety. And that's really like harmful. I say that because there's really community members that are right now on ankle monitors that spent, decades in prison, went through the grueling parole board process. What I did when the number one job of the parole board, the commissioner, is to say, are you a risk to the community? And they spent 6 to 7 hours grueling you, and you do a psychological assessment, all that. And then they recommend parole, right, to the governor. The governor lets you out to say, like, yeah, you're not a risk, go ahead, welcome to the community, but best of luck anyways, since you have an ICE hold, we're just gonna turn you over to ICE, right? But then ICE really grapples to that narrative to say, no, we're gonna continue detaining the person despite whatever record they had, right, in prison, being found suitable, because they continue to base them on these convictions, right? And then if they're lucky, they get put on ankle monitors. Like one of our clients, he was in ICE detention for 2.5 years. He is still on an ankle monitor like 4 years later. It's really unnecessary, right? And he's a great community leader. He's doing so much. And why would he even risk of fleeing the country, right? He's doing everything X, Y, and Z to go above and beyond. To say, this is my home, this is the only home I've known since I was 2 years old. But ICE continue to say, like, he's gonna be a threat, like he might flee, right? And that is the narratives like they want you to believe, right? That we're keeping folks detained, we're putting them ankle monitors, because again, I think, right, it is like me say, it is a system that wants to set up them for failure. It makes it difficult for them to abide by, right, whatever rules the ICE has, especially like not getting notices in the mail, or sometimes they change check-ins without a moment's notice, and then they want to violate you, right? I think this is really harmful in a sense, and I think for me, like that surveillance is true. Like they want to continue. Ankle monitor is a form of surveillance that that really I don't believe in. It's a concern. They to build trust with the communities, you must say that community members are willing to abide by, because they're going to do everything within their power to remain, right, to fight the immigration cases. And if they do have a final order of removal, why would they risk, right, any more harm to their family members or to, right, to whoever they're working with, especially if they want to, be voluntarily removed. But that's another issue, right, of ending deportation. That's another, not for this panel discussion. But yeah, that's how I feel.
Oh, Meeth, did you want to add to that?
Can I just add a couple of points to what Nia and Margot have raised? And, I think that I agree with Margot with respect to the, we're like, as far as like from a movement perspective, to say that, we're not going to accept alternatives to detention if there's like ankle monitoring, if the option is like either we detain you or we don't. Yeah, I'm going to definitely, because I think Margot's right. If you ask our client, and those are the people who really, it's like, that's their choice, and the community's choice and impacted members' choices, as Nia said, is like, detention is horrific. And so any alternative to that is, of course, is what we're going to choose. But I think here, I think that we would be remiss if, given the particular moment that we're in right now as a society, where finally it's like coming out in the open, we're able to openly have conversations about the ways in which race, status, nationality have been part of policing, have been part of otherizing, and the ways in which it's lent itself to institutionalized systematic forms of discrimination. You know, this whole, the policing of immigrants has been part of, you know, it's like part of our country's history. And it's one that we've been, I feel like it's a process that we take a couple steps forward, a couple steps back in trying to dismantle. And, you know, I think that, and so I just, and like, why is that? You know, why is our country so obsessed with policing, particularly like immigrants, foreigners? You know, it's just that we're constantly perceived as this threat. And I think that the system that we've created around detention and then alternatives to detention that really borrow from like the criminal justice sort of mindset and framework of assessing someone's danger or flight risk and whether they should be given liberty is, I think it's cornered us and put us into a place where it's criminalized status. It's criminalized being an immigrant in many ways. And so you know, that's just another sort of what I kind of want to put out there when we're thinking about these practices and where do we go from here, that we should also be sort of kind of using this moment to also bring those questions and to inform us in how we sort of go about doing advocacy around this.
So that's a great segue to, you know, one of the, I think, overarching questions when you talk about abolition is how much do we want to align this movement to abolish immigration detention with prison abolition, right? And I think this is just an ongoing tension in the immigrants' rights space with how much is this really about a larger problem of criminal enforcement, of mass incarceration. And I think advocates have gone really different ways in trying to distinguish immigrants as a different kind of population and ally with these efforts to understand it as all part of, you know, some of the deep history that Meeth was referring to, of this is about a long history of racist policing and racism in our immigration law. So I think one way to look at this is through a specific issue, which Nia touched on, which is in California, we have this statute that is, there's advocacy building to basically ban all transfers from prisons to immigration detention. But that we're California and we're, you know, kind of, I think when I was in Arizona, California was always just like la la land, like, you know, whatever's going on there, well, that's great, but that doesn't help us here. And I think that a statute like this is a great example of that, right? That's probably never going to go anywhere in most of the country, but there are efforts to ban transfers to detention for like certain types of after people have served sentences for certain crimes. So I'd love to hear from the panelists about whether they think that's a good direction for kind of strategically and in terms of this movement to try to have carve-outs where you don't have transfers for certain types of criminal sentences once they're served, or whether that's furthering this sense of distinction between immigrants and quote unquote criminals. So I would love to hear thoughts on, and you don't have to speak to that specific statute, but this tension in the movement.
Yeah, I can go first, and thank you, Meeth, for addressing that, and truly agree that systemically it's an issue within the criminal justice reform world and the immigrant rights world, that it is racism, right, racial violence, the targeting of immigrants, refugees, of our Black and Brown communities, right, that it is, if you think about it, like the policing, the incarceration levels in the state, in the jails, and then how really detention and deportation, ICE transfer is really from state and local jails. It's the main pipeline, right? That happens. That that 70% of ICE beds are from state prisons, right? That is the relationship that's really sickening. That's why in California, we're with this policy, with this legislative bill, if passed, that could be, the segue, the model for other states to say that, if we live, if we are protecting the most, like the vulnerable population that people don't want to talk about, address about, that we have to really have these serious discussions about why do we have a mass incarceration crisis in the first place, right? Why are we an immigration system that deports the most, right, in the US? Why are we continuing to criminalize people that have served their time? It's like, it's really an hypocrisy when they say like the criminal justice is rehabilitation, but at the same time, why aren't immigrants a part of, part of that as well, the equation? Just because they're born somewhere, or just because, why are we continuing to, we need to really challenge lawmakers that made these complex immigration laws that makes it really difficult, right, to challenge, especially we're talking about people from poor backgrounds that grew up in violence. That's like all they know. We're talking about people that really needs to be in the center of all this. I think what I'm saying is that it's necessary to really uplift their stories, and we're working at the local, right, and the state level to really change that narrative, to really say that we would like for people that are federally, the Congress members, to say, look to them as as leaders, as people who experiences these types of violence, why they end up incarcerated in the first place, or why didn't they, or some people don't even realize that people that are getting deported are even unlawful residents, but then they have to understand, like, why do people migrate to the US in the first place, right? I think everybody wants a better chance of living, opportunities, fleeing, asylees, fleeing war, fleeing genocide back in, during the war in Vietnam, and all of that. I think the US really has to take a look at itself and continue to hold itself accountable and really be pressured, right? Especially the Biden administration now, to rethink about immigrants, that just because of their conviction alone, that doesn't make them less worthy, less valuable of having the same opportunity, just any like citizens, right, that are born here. I think we really need to look at that and really challenge ourselves, especially in the immigrant rights world, to say who's more deserving or undeserving, and really just be open, right, to, I know the work is hard. It is. It's so much easier to represent, DACA, to talk about, and all of that. But if we ultimately want a world that we want to, end incarceration and deportation, we have to really, work together in this.
I feel like the immigrants' rights and pro-immigration movement has sometimes really worked hard, as you said, Nina, and as Nia just said too, on this: we're not criminals, we're regular people, we're good regular people. And sometimes they've done that in ways that my background is as a prisoner's rights lawyer. I've had conversations with people where they say things like, like the jail conditions are terrible. The immigration detention conditions are just like jail, and our people aren't criminals. They don't deserve to be treated like that. And they're talking about medical care. And my view is that I mean, for one thing, jails are 70% pre-conviction, just by the way. But even apart from that, even if you're post-conviction, how does it come with a conviction that you get like the government disables you from getting medical care that you get to pick and then gives you none or crappy medical care. Like that's unconstitutional, and the Constitution has been clear about that for a good long time. So the idea that, oh, but that shouldn't apply to immigrants because we're not criminals, I find really problematic, really problematic. And so I think that move has to be really interrogated. You're asking a hard question. As a matter of strategy, it's very important. Let me say that differently. It's very important that people not be deluded about where numbers of folks in prison come from. Most of the people in prison are not in prison. This is not true for jails, but most of the people in prison, not all, but most of the people in prison are not there for tiny little victimless offenses. And so if you start doing carve-outs where you say, well, but if it's just weed possession, then you're not covered by whatever bad thing it is, you're not going to hit very many people. But and so if the goal is to stop the transfer of folks from prison to immigration detention, if that's the goal and you want to disrupt that transfer, then any carve-outs have to be small rather than the people covered by the disruption having to be small. But would I rather have 90% than zero? I mean, legislation is a compromise activity, and yeah, I'd rather have 90% than zero. And so, as I've said before, I've already said, I don't believe that immigrants should be subjected to preventive detention. If they've served their sentences, they're no more dangerous and probably less dangerous than non-immigrants who have served their sentences. And I don't think that it's appropriate to deem them dangerous simply because they've been to prison. As Nia said, they're getting out of prison because we actually have reason to think that they're no longer deserving of prison or dangerous. But in any event, I guess what I'm trying to say is, if you want to have a carve out that says except murder, then that's not going to be very many people, and it might be that the movement gets a huge amount of what it wants. Is that compromise worth it? That's not a strategic, well, it is sort of a strategic question. That's not a principle question. That's a principle of strategy and tactics. And it has to be decided in each state, looking at the realm of the possible and thinking about what it is that you have to give up to get something else. But I'm sorry, I want to return where I started. I do think it's really important for the movement not to fall into the trap of acting as if a criminal conviction renders somebody unworthy of humane treatment. I think that's wrong. And it's unhelpful in the ways that Meet talked about, but it's also just wrong.
Meet, do you want to add anything? Or I have a slightly different take on this, but if you have anything to add first.
I just have a very quick point to make, and just to kind of piggyback on Margot's point about compromise, and because that is, I feel like, the history of what we've seen happen in California, where there was originally kind of this carve out for who was going to kind of be allowed, where who can ICE pick up and stuff. And now we've moved to the point where we're like, no, carve out. And I think that that's, really an important sort of something to hold on to from the perspective of advocacy, that it does happen in increments. We're not going to get everything all we want in one full swoop, and that shouldn't be a reason why you resent advocacy or kind of give up on it. That it's a long process. That said, I do think that one of the things that we always as far as what California is concerned, Nina, you mentioned this, right? In Arizona, anytime I talk to an advocate outside of California and they realize that I'm giving them advice based on my experience in California, they're like, oh yeah, okay. That doesn't work for the rest of the country. The rest of the country doesn't have the benefit of the wonderful sort of and I say this with an asterisk, it's just that the Ninth Circuit sort of case law that we have, that we get to sort of force the immigration courts to follow, but even that sometimes is hard, but is generally much better than the rest of the country. And so, that being said, when we start abolishing kind of ICE and the detention facilities in California, the question that we always have to I feel like, especially as a direct services attorney that is incumbent on me, is what happens to those in California who ICE does want to, sort of put into removal proceedings, and ICE does want to detain? Will they then move them to cross state lines, do whatever it takes? And, the sort of the impact that that's going to have then on families and our immigrant communities in California. And, how have we thought that through as an advocacy community? And I'm not sure that there isn't consensus, and there never will be consensus probably on that. But, I think that where you fall on that can also, it might mean that some of us might not go so hard on certain advocacy points, or might not support it as strongly as we do others because of our other obligations and sort of the other needs as part of this movement. So that's what I just wanted to add.
No, I'm glad you did. That was actually my tag on. And so I'd love to hear if people have a little more to say, because I think that is another kind of application of this tension, is how much do we focus on individual facilities? Is that an important part of a national strategy towards, even if not abolition, because we've talked about that, even if it's dramatically changing the volume of detention in this country, is focusing on closing down individual facilities the best route to that, by drawing attention to sort of the worst of the worst? Or is that actually, like Meeth was just suggesting, just going to end up having those people sent somewhere else? So any further thoughts on that tension?
It's not usually the worst of the worst that gets shut down in those campaigns, because the worst of the worst are in places where those campaigns would fail. And so that's why there is this tension. I think that as a strategy for reducing our capacity from 55,000 to under 10,000, you got to take some facilities offline. I mean, there's no question about it. That's the way to do that, right? Is take some facilities offline. And so that's a sensible advocacy strategy. The cost of that advocacy strategy, which is not borne by the advocate, but by the people who end up detained elsewhere, is that rather than being detained, say, in California, they end up detained in Nevada or Arizona. Rather than being detained at, for example, this is the same conversation we could have about some private detention versus county detention, right? Rather than being detained at a private facility, they get detained at a worse county facility because there's been a movement to shut down private detention. And so capacity has been shrunk, and some people are not in detention as a result of that, and they are better off. And some people are worse off. And we don't know in advance who's going to be in which category, and they're not the ones deciding the advocacy strategy. And that is an ethical dilemma that I think the solution, and it's not much of a solution, but the only solution is to make sure that impacted communities are part of the decision making about strategy. At least then you're talking about members of the affected communities who are deciding what to do. Whereas otherwise what you end up with is the lawyers deciding, and that's just very unattractive. So but there's no escaping the basic ethical dilemma, which is that by shutting down things that aren't the worst of the worst, that one doesn't raise an ethical dilemma, but by shutting down the teeniest bit above average facility, you push people to worse facilities, and some of them are going to be worse off.
Nia, do you want to add anything, or?
Yeah, I think in terms of, it is. right? That we have no clear answers. I think we all can agree to that. And definitely, we don't believe in carve-outs. I think in terms of like when you hear about people that are convicted of murders, or right, or people that are serving life without parole, like for myself too, I think people that are with these convictions. I think when we think about it, like they were not like the main perpetrators, or that we have to understand the situations. Sometimes when people get convicted, especially in California with these excessive form of sentencing, the way they got convicted in the first place, right? They really did not have any legal protection during their criminal right proceedings, whatnot. And then it just they continue to be labeled, and their convictions continue to follow them, especially being an immigrant, right, that's facing deportation. And I think what we're doing is saying that carving people out that have certain convictions, it's really not the remedy, and it's going to continue to perpetuate, right, the immigration system that really want us to believe that the only way that the immigration system works is that we continue to build this narrative of good immigrants, immigrants that do wrong, punish them and deport them, and not clearly giving them an opportunity to challenge their case. Again, once they're funneled into ICE detention, the SOL should have had luck, really, because they have no, you don't have an attorney, you don't have any monies, therefore you spend 1 or 2 years in ICE detention, it just wears you down, and you just take your chances of being deported, right? So what I think that we really need to do is, yes, if we shut detentions down, and then if I find other ways to take them out of state, as long as we continue to push this administration to build on the nerve, like detention is not necessary. Detention is not necessary for people with these type of convictions. Let them be to fight their immigration cases. They have communities that are willing to, that have resources, that have families and loved ones that can take them in, to say that my loved one or my community member is not going to, break any immigration laws or whatnot. I think what we want is, again, the opportunity for people to not continue to be punished, to be in ICE detention, especially they have served their time, right? And they shouldn't even, they're not even, I mean, this word of criminals, like to call them criminal, to say they're a bad person, that they should be locked up in the first place. I think, there should be other alternatives to, incarceration, right? So I just wanted to, to say that, like, it is going to be a challenge. It's hard work, but again, we have to really, again, I can't stress it enough, just lift from the bottom up, talk about the most serious why, and understand who they are, their lives, how they end up really in the criminal legal system in the first place, right? Especially as being immigrants, the racial violence, especially women, domestic violence survivors, especially like, Black immigrants that are 20% that we know are part of it, are being deported too. But that's really, that's not what we really hear, right? Yeah, I just wanted to uplift that.
Yes, absolutely. So I'm gonna cover some of the great questions we're getting from the audience. Please, if you do have questions, put them in the Q&A box, and we'll try to sort them and cover at least the topics that people are raising. And one of the topics is the fact that so much detention is the private prison industry. So, just generally, I think it would be interesting to hear your thoughts about how that should fit into the movement to end immigration detention. I'll read, though, part of this question. Immigration jails are located in isolated places, making it difficult for lawyers to give service and humanitarian organizations to pick up people when released and give them help. And private prisons are making money off of these immigrants. How do you see the opportunity to denounce this? Is this acceptable? So I guess, I think one of the questions here is the fact that private prisons are such a big part of the detention system, and how does that factor into the detention advocacy strategy?
I mean, well, Margot, I'll take that. Or okay, I think, yeah, I think that it's a huge piece of it, and you know, to the extent that right now, the Biden administration is really has announced that they're going to end these at least from my understanding, or was one of their promises, right, was that they were going to end private prison detention contracts, or make that effort. I think we also need to make the same demands of immigration detention, since they're by and large the biggest entities that are detaining people. And I could tell you from once with the private detention facilities complicates so, I mean, besides for the fact that their conditions there are abysmal and there's no form of accountability within the immigration detention system, when you add this layer of like a third party that's been contracted, it gets even harder to hold anyone accountable. And I think that, once you kind of get people to start, like if we can end that system of where people there's like a monetary interest attached to detaining people, and then we're looking, it just kind of takes us closer and closer to the goal of abolition.
So I'm not against the idea of getting rid of private detention. It's the easiest way to get rid of masses of detention beds all at once. And so that seems like a reasonable approach to me. That said, let's just be clear. ICE does not run any of its own detention facilities. And so what we're picking between is private or county. Those are the choices. Both private prison companies, Core Civic, Geo, and the others, but those are the two biggest, and counties have monetary reasons that make them want more people in detention. And both private prison companies and counties have massive accountability problems that mean that there's 3 layers or more between ICE management and what happens in a detention facility. So getting rid of private detention will not solve either of those problems. In fact, it won't even, it's not even like the private ones are worse than the public ones. If anything, in general, my guess is that the county conditions tend to be worse than the conditions in private facilities. So I don't think it's a good idea as an advocacy movement for us to blink that reality. I don't mean to accuse you of doing that, Mead. I just mean, like, sorry, I'm kind of getting myself ahead up here, but I don't think we should avoid that reality. I think we should acknowledge it and know that that's what we're doing. So if you could say to me, hey, if we got rid of private detention, we'd increase accountability and we'd increase amenity and we'd decrease the role of money in immigration detention, I'd say, hey, that sounds like a no-brainer. But I actually don't think it does either of those things, any of those things. I think what it does do is it gets rid of a whole lot, thousands and thousands and thousands and thousands of beds. And so, like, let's just say that's why to do it. Do it because it gets rid of thousands and thousands and thousands of beds. But don't think we're improving accountability, because if anything, it's the opposite.
And I just want to add, just if I can, just really quickly respond to that. Sorry, because and this could very well be just like my limited experience of only doing, detention advocacy, detention work in Southern California. So I own that. But I guess maybe the way I think about accountability is in part that there's what I've seen through my experience is that, in Southern California, advocates have been really successful in and Northern California too, in getting county jails to shut down. And they've done it because they're elected members who are making these like provisions and entering into these contracts with ICE. And once you get the people to vote them out or put that pressure, we've noticed that that's what's led to like shutting, those facilities down. The same is not always true necessarily with like ICE and like when they enter into these like private contracts. It's much more complicated to end that system. And so that's what I kind of mean, that there's more of a
so this is
accountability
fair.
in that way.
There is democratic accountability of sheriffs, which Core Civic doesn't have, or whoever. So that's fair. If that's the point you're making, I can't possibly disagree with that. That's absolutely correct. And I don't. I mean, in some ways, there's the accountability is it's just a little bit different across them, I guess is what I want to say. But jails in Arizona, Northern California, like way up in the tippy top north, right? Georgia, those polities are not voting those sheriffs out of office because they have ICE detention.
Yeah, do you have thoughts on the private prison industry and that aspect of the issue?
I just want to say that in terms of that, like in California, sheriffs like Los Angeles recently are not working with ICE, right? And San Francisco, I mean, yes, California is like the leading state that are aiming to abolish ICE entirely in California. I think that we have to really think about that it is possible for other states to do the same, right? To get rid of ICE in their states. If you get rid of ICE in all the states, you eventually get rid of the system that really perhaps one day will stop detention facilities, period, right? And allow folks to fight their immigration cases, especially if they're facing deportation. Yeah, I think really it is like, there's no easy answer. I think the only solution is that we continue to work on it, period, and abolishing means also working on reform. I mean, reform is necessary, right? But I think once we get these legislation met or reform worked on, abolishing is doing what we can, right? Compromising, but if it's compromise that has to do with to say who's more deserving or who should be carved out, that is not what we're working on right now in California. That's why, again, the legislation that we're running, it's really crucial that we want California to be, right, to pass this and be the leading state to encourage other states to do the same.
Great. So we have a really interesting question here about something we haven't really talked about, but such a huge piece of detention has to do with access to counsel. And a lot of the movement for universal representation and right to counsel is grounded in actually detention now. So this question is, do you have views on how to reconcile some of the tensions between the movement for universal representation that's been particularly for those in detention and the abolition movement? Your comments on site fights brought to mind instances in which legal service providers funded through universal representation programs have advocated to keep a particular facility open to give access to legal services. So, how can advocates do a better job of affirmatively addressing these tensions?
One of the things that is really important if there's, well, all right, so two different points. One is if detention is going to be smaller, but here, one of the things that should be true about where people are detained is that they are detained in places that make representation, legal orientation, finding, dealing with experts about asylum, etc. The things, getting them appropriate medical care, all of the things that come with detention. You want detention to be cited in places where that stuff is possible. If detention really goes away, or even if it just stays very small, it does mean that the universal representation movement has to shift to a more diffuse kind of client population. And, you know, one of the things is, someone who's represented prisoners in a bunch of things, it's not that I ever want my clients, I mean, often my representation doesn't have anything to do with them being in prison. I guess what I'm trying to say is, it's not a question of whether I want them in prison or not, which is irrelevant to my representation. One of the things about them being in prison is that I know where they are. And one of the things that we all have experience with, I think, is that when people get out of detention, they're better off, but it poses, sometimes it can pose a real challenge to the representation because you can't find them. It behooves lawyers to think about that in advance and build the structures that they need to know how to reach people when their phone gets cut off, and to know who their relatives are, and to know where they live, and to, but again, we shouldn't pretend it doesn't pose challenges. Of course it poses challenges. I mean, we have to admit that.
And, you know, I can relate to that, to the question that was asked. It's just that it's just a forever sort of very awkward place as for myself to be in as a direct services attorney who's representing individuals inside detention facilities, is if it shuts down, and, you know, we've worked to get access to counsel for a certain detention facility, what then happens? You know, I think that that's kind of one of the maybe part of the universal rep movement, to the extent that it's really focused so much on getting access to counsel, prioritizing individuals who are detained. It doesn't necessarily gel all that well with, I think, the abolitionist movement, because we kind of haven't thought about, like, well, what happens when, like, you do actually succeed in shutting down a facility, and then and where do we go there from there for universal representation? But I think to that, like, I don't feel, you know, sort of that I'm even in a place to answer that question, because I have that bias of being a direct services attorney who's, like, you know, sort of advocated for representation of those detained. But I think that, Nia, I would love to hear from you on that point, and like what, like, as someone who's been impacted, and like what you'd have to say.
Definitely, I want to say that they are amazing attorneys that I work with, that I know, especially with my Asian Law Caucus, that always talk about, we wish we could provide, you know, services, you know, represent people, clients, whatnot, but they're responding so much to rapid response, because once a person is detained in ICE detention, they have so much time, right? I think universal, you know, representation, like every person that, you know, that has are facing deportation, that have an immigration case, really, like, for myself, the laws are really so difficult and complex to understand, right? And so we were not attorneys, so in order to understand, to go what we're up against, especially that we need support from, like, you know, lawyers that are able to help provide that support, and not just like lawyering, what I mean, like, you know, doing the paper, whatnot, but it's also like to get to know the clients, like to build relationships, to understand what their needs are, right? Especially when they're facing other impact as well, like financially, how, you know, to connect with community resources and whatnot. I think that there's a need for more funding, you know, for lawyers, you know, especially, you know, that sometimes they're not able to pick up cases because of, you know, certain convictions that people hold. The funding, you know, it's really limited. So I think that if we're able to provide that, for clients, for people, I think that, that would really help. Able to work with public defenders, district attorneys that's willing to reduce their convictions to non-deportable, right? We've done that too. And we have, again, majority of people or clients that we know, they have cases that is, right, fightable. That deportation could have been prevented if they only had, lawyers or attorneys that were able to provide that. And then sometimes once we find out, it's kind of too late. I mean, in a way, it's great. We've gotten community members that have been deported back home, but again, it's again really crucial that every person that's facing deportation have a representation, know like what's going on, instead of like, yeah.
Great. So with our remaining 10 minutes, I want to ask one question from the audience, and then I have one final question for the panel. The one question from the audience we haven't touched on at all is the issues raised by the detention of children and family detention, which I know Margot has worked on. So any thoughts about the particular challenges raised by, right now we're seeing that despite all of the other things dipping, I think that the issue of at least short-term detention of children is really not on a downward trend. So thoughts about the detention of children and families and how that is that really like a different movement? Is that part of the move towards abolition of detention? Overall, how does that fit into this conversation?
I think family detention, as I understand the current state of play, has shifted to be entirely very short term. And I think that's a very good shift. And so, but focusing on the detention of children, there's really 4 or 5 different problems shoved together under the detention of children. There's the fact that CBP hold rooms house kids for days and days and days in settings where nobody should be for more than really a few hours, settings that were not intended to be residential, and with staffing that has never been really trained and certainly isn't signed up for and isn't committed to the idea of running, what is essentially kind of a camp. I don't mean camp like summer camp. I mean camp like refugee camp, just to be clear. I'm not saying that this is like summer camp, right? So it's the wrong staffing pattern. It's the wrong physical setup. It's everything about it is wrong, which is why the rules say you can't be there more than 72 hours, but the system currently isn't working that way. So that's one set of problems. And the system has to be improved, and many pieces about it could be ironed out to improve it some, but to improve it a lot, what has to happen is either an increase in capacity or an increase in throughput, if you want to call it that, in getting kids out of ORR detention to free up the capacity that's there. And to do that, they have to have better, more efficient, more effective vetting systems. But at least, I don't mean to say that it's a good system currently, but at least it's not, for most of the kids, it's not a jail-like setting once they're in ORR custody. Now, that said, there's actually another problem that nobody really mostly acknowledges, which is the kids who are suspected of criminal justice involvement then go to basically juvenile detention with no safeguards that I'm aware of. And it's the forgotten population. It's like, oh, well, shoot, they're the bad kids, so they can be kept in jail. And I hope that at some point, as the nation spends more attention on this population, that we can actually open our hearts to those kids too, who are children, who are going into outrageous confinement in ways that just lack justification. But I guess my general point is that this is at least they're not in once they get out of CBP and over to ORR, if they're not thought to have criminal justice involvement, at least they're not in jail-like detention. And the problems are sort of a different set of problems that have to do with finding the right custodians and releasing them. And there might be some front end things that could be done that acknowledge kids as not unaccompanied if they're with certain kinds of more extended sorts of relatives, those sorts of things that would keep some of the kids from going into that system. But that's a little bit at the margins. The numbers are what the numbers are. And you can't take a 13-year-old and say, oh, well, since you're here and we don't want to detain you, okay, you're good. Like the government has an obligation to find them an appropriate housing situation. And that's what's currently taking so long. So it's a completely different set of problems, except for those kids suspected of criminal justice involvement, where it's actually not a completely different set of problems. It's actually a very similar set of problems.
Yeah, I couldn't agree with you more, Margot, and I just want to like emphasize, I mean, one point that I just really want to sort of take the opportunity to emphasize is the role of CBP, and just given that, I mean, CBP with adults is abusive, and I'm going to spare the audience like the stories that we hear from our kids of what CBP and how they mistreat them. And I think that this is probably, one of the sort of reforms that we definitely need to see is to not have CBP have any sort of interaction with kids, because the agency is completely ill-equipped, they're not trained, and it's a very hostile sort of agency, and so I think that, kind of thinking about right now what is happening, especially like in California with the emergency intake sites being set up throughout the country and the ways in which they're working, it is offering a very different model of what that would look like from the time a child presents at the border and being immediately transferred to a place where you are only interacting with social workers, and sort of trained advocates, child advocates, and legal service providers to care for that child and try make sure that that child gets processed as quickly as possible out of there, and not having to prolong any sort of interaction of that child with CBP. I think it's really important.
Great. I'm going to ask one last question before this has flown by. But my last question is kind of because this conference is about the 100-day marking 100 days of the Biden administration. Like, given this new administration that we're working in, does that shift the strategy for detention, abolition, or working towards an end of detention? And I guess specifically, we're going to have Mayorkas here next week. Like, are there particular questions you would want to ask him about detention and abolition? So any thoughts about either sort of strategic thinking around detention advocacy in the Biden administration, particularly in contrast maybe with Trump, or specific questions for Secretary Mayorkas?
I mean, like off the bat, this is one thing that I feel like we've been kind of left in the dark, or at least maybe, I mean, there's others in the audience, especially if you know the answer to this, please let me know. Which is like, what is their enforcement priorities? And are they, like, given the record number, like the low levels of detention, can they commit to maintaining that? And then, like, that's kind of like sort of, that's the number that we have to deal with versus like, there's assurance, I guess maybe put another way, just, is he willing to give us assurances that they're not going to increase the number of detainees and that from here we just go to lowering the number of people detained?
I think my question would be for him is that the Biden administration is giving really ice, right, the agency to say who's really pose a risk to the community, right? So I think anyone with the felony conviction, especially coming out of state prison, ICE is really going to prioritize the arrest, the detention, the deportation of them, and not allowing them to be released, especially like opportunity out on bond, you know, if they have merits for that. I think that really want to ask Mayorkas, if we're thinking about, you know, working alongside the Biden administration, we want to think about what is criminal justice system looks like, especially for immigrants, right? Because they are part of this systemic like incarceration that's happening, right? That how do we deal with that? How do we encourage, you know, Mayorkas, for you to listen to the advocates, family members, the communities who are directly impacted? How do you reconcile? How do you not, you know, how can you work with the administration to not continue deporting community members that really should be deported, give them opportunity to have a better chance of finding their immigration case without detaining them, right? Once they're detained, it's going to be really hard to get them released. Once, you know, I think, you know, those are my questions. Like, how do you really work on the criminalization together and not just continue that rhetoric that, you know, people with these convictions should be detained and deported?
I think I would say the the Biden campaign promised an end to private immigration detention. The Biden administration's executive order on the topic of private incarceration omitted immigration detention. Is ICE going to dial back on, shut down private immigration contracts? I just would like to know the answer.
Great. Well, there is a lot more we could talk about, but I think we're at time. So thank you all so much. This has been fascinating and really helpful, I think, in sort of gearing up for the fight we find ourselves in the new administration. So thank you all, and I'll turn it over to Hiroshi.
Yeah, I just want to, don't want to keep you any longer. I just want to offer quick and very heartfelt thank you for all four of you. There's been such a rich discussion along multiple dimensions, right? I mean, it's not just what the goal is, but what does the road to that goal look like? What are the trade-offs? Maybe the false trade-offs. It's been really rich and a great conversation to have. I also want to thank, in addition to the panelists, our large audience today, and I hope that you're able to join us back here next Friday. And just give a little preview, we'll have a morning panel on movement lawyering. In other words, how does change occur, and what are the roles that various people play in effecting change through law, through organizing, through other modes of advocacy. That's in the morning. And in the noon conversation, that's the conversation that Ahilan will have with Secretary Mayorkas. Turns out that's exactly the 100th day, if I have the math right. And I'm sure Ahilan will ask the Secretary some tough questions. I mean, that's the way we've set it up in the Secretaries. Agreed to. Then we'll have an afternoon conversation about the future of asylum, refugee protection, more generally, how to respond to forced migration in general. So I just want to also say as an overview that the speakers for day 2 will be, and like today, some of the leading scholars and academic advocates in the country. And we'll also have voices from an additional array of significant organizations, including, just to name them, African Communities Together, Mi Gente, Haitian Bridge Alliance, and Al Otro Lado. So I'm really looking forward to that. And just a couple, just the one logistical note is there is a separate registration and Zoom link for day 2, also a separate one for day 3. So please do that as opposed to using today's link. So last thing I'll say is I really wish I could invite you to a reception outside in the courtyard, but maybe that'll have to be for next time. But I really look forward to seeing you next Friday. But for today, we're adjourned. Have a great evening, weekend, and week, and I hope to see you next Friday.